now to a high-profile prosecution, which appears to be colliding with high constitutional stakes. The DSS has filed a 3-count charge against former Kaduna State Governor Nasir El Rufai, alleging unlawful interception of the National Security Advisor's communication, alongside failure to report a cybercrime and conduct capable of endangering national security. The case now sits before the Federal High Court in Abuja. But beyond the headlines lies a harder legal question. Does a televised political remark amount to proof of technical interception? Can commentary substitute for forensic evidence? And where does prosecutorial discretion end and constitutional restraint begin? Is this a necessary assertion of national security law, or a case that will ultimately rise or fall on the rigors of hard evidence? Well, Chief Festus Ogwuche is a lawyer and president of the Campaign for Social Justice and Constitutional Democracy in Africa. He's written an article arguing that in criminal law, gravity must be matched by proof, and rhetoric cannot replace evidentiary discipline. And Barrister Ogwuche joins me now on the line from Port Harcourt. Thank you very much indeed for joining us, and thank you for your patience as we debated the electoral matters here in the studio. Let's start with the evidentiary threshold, because you argue that gravity must be matched by proof based on what is publicly known, which is all we know at the moment. Do you believe the prosecution currently meets that threshold?
Well, thank you, Charles, for bringing me on here. This threshold is defined by law, hard law, and not sentiment, so rhetorics cannot come in. The evidentiary threshold is very strong, particularly if you're dealing with cybercrime and issues relating to telecommunications, because they are provided for by the law. You cannot deviate from the essence of the path that it has already created. The nucleus of that threshold is defined within the ambit of the Cybercrime Act, and which act requires that there must be an intentional disposition of the accused person or any suspect, anybody suspected to have committed that offense. It's not just that it should be intentional, it should be unauthorized, and it relates to technical interception. And these matters are things that will meet with the standards of trial in a criminal matter beyond reasonable doubt. I've taken a look at the 3 charges, the charges formulated, and I begin to ask myself question whether it actually meets the demands of a digital investigation, whether it was there has been a proper digital investigation as to make judicial scrutiny an easy sale, and I doubt if it is. Because apart from the dearth of substance and material in the 3 charges, I also see it that it does not meet the required standards of maybe a charge, properly so-called, in a matter of this nature. Cybercrime, which proof must be very substantial and substantive, requires forensic evidence, requires forensic investigation. It takes a lot to understand that the allegation must be specific, and it must be identifiable, and it must be legally attributable. You must attribute directly to a particular person, not to an individual who's unknown, or probably somebody has made a speech which can fall within the realm of circumstantial evidence, and you think you can bring it as a charge, and somebody is on a television just as I'm talking now, and they make reference to something somebody else has done, somebody you do not know. But then you look at it again from where the burden of proof starts. It starts from the prosecution to prove that there has been actually a tampering or an interception in the phones or the communication devices of the National Security Advisor. How will they go about it?
But let me come in here.
So I think they were a little too hasty.
Right, let me come in here, Chief Ogwuche, because of course it is possible that the public simply hasn't seen the strongest parts of the DSS's case yet. in that regard, I mean, if forensic evidence later shows device traces, for example, or digital logs linking Nasir El Rufai to an interception, would your position shift considerably?
It will shift, but then I'll still have some reservations. Reservations in the sense that El Rufai may not be the actual person to be held responsible for that or to be culpable for that crime, if it shows, except he's an accessory after the fact, or maybe there's been some conspiracy on his part. But if it is something, because he said he got knowledge of that transmission, that interception, it depends on the fallouts of the investigation, which must be thorough and lead on very solid grounds as to attract a proper judicial scrutiny.
Right. Let me put it another way. Let me put it another way.
Okay.
You say in your article that criminal liability attaches to conduct, not commentary. And I think you made the same point here. But can public admission of knowledge also amount to incriminating evidence? I mean, if someone publicly references an intercepted call, does that not at least create probable cause for investigation?
Probable cause for investigation, yes, and then the investigation must be thorough and direct. It must show that there's a direct activity of the gentleman responsible in that particular action as to attribute illegality or criminality to him. But if it is founded on wishy-washy investigation procedures that does not touch on the substance and the real issues surrounding that interception, it cannot stand. To sustain a criminal trial, it requires a lot of, particularly under the Cyber Crimes Act or any of these telecommunication areas of activity, it requires a whole lot of thoroughness, because like I said, it has to be digital. Proof has to be digital, and we don't bring in circumstantial evidence into it at all. If somebody had tampered with the device of the National Security Advisor, which I consider to be very serious in all its ramifications, of course that person will be directly culpable for it, and not that somebody said and that other person said that. That is upon proof by the prosecution that there was actually an interception and a tampering with the device.
Right. Well, I mean, as you said, if the NSA's communication was indeed intercepted, that would automatically constitute a grave national security breach, regardless of how it happened. But in your article, you also raised concern about prosecutorial authority. Are you suggesting, just for the sake of clarity, are you suggesting that the DSS may be overstepping its constitutional remit, even if it has credible intelligence? Because you seem to be suggesting that it would have been institutionally cleaner, let me use that term, for the Attorney General to take the lead in filing the charges.
I am not suggesting that the DSS had overstepped any bounds. I am only saying that it had no bounds to step. The Department of State Security Services, we see it, a lot of people see it as an offshoot of the SSS, which exists under the status. But the later baptismal understanding of what it is now does not exist in any statute book. For prosecutorial powers to be existed, or to be said to be existed, it must have the necessary mandate. The legal framework must be there, and it must be dominated by that statute or by the provisions of the Constitution. The Police Act there, for instance, is very, very clear on it. The EFCC Act, also the ICPC Act, but which portion of the Act, which portion of the law gives the DSS the prosecutorial powers to file charges in the court? Somebody had argued that the name of the Attorney General is in the matter. It doesn't really matter. The Attorney General cannot donate that power to the Department of Security Services, even by way of fiat, except if it had been properly mandated under a statute, under the law, and it doesn't exist under a law yet. So the prosecutorial powers is very, very important in determining the inclinations on the powers of the DSS to file charges. This argument has been going on for quite some time. And remember, it's an intelligence organization. It's there to gather intelligence for national security to ensure that the internal security is not prejudiced. But where it gets these prosecutorial powers to file charges and to arraign or do whatever, what they usually do is that somewhere in the middle of the trial, they will withdraw, and officials of the Ministry of Justice or the Attorney General will take over the prosecution. But that is not what the law requires, because as far as I'm concerned, I looked at the names there on the charge sheets. I think there are about 5 of them, and they are all lawyers. Yes, they have the power. They are solicitors and advocates of the Federal Republic of Nigeria. But for them to file a charge under a non-existing institution, it will be regarded that they are private prosecutors, and then for them to sustain it, they have to go through the procedure under the Administration of Criminal Justice Act to bring criminal charges as private prosecutors.
Right, okay.
So it cannot transform or transmute from a private prosecution to a public prosecution back and forth by the authority of the Attorney General.
Right, okay. We're almost out of time, and I apologize for that because the debate we had earlier sort of ate into the time that we had allotted for you. But you write that Nigeria's democratic maturity will be measured by institutional fidelity to due process. If this case collapses for lack of proof, what would that say about institutional discipline? And conversely, if the prosecution succeeds, will that validate the DSS's approach or simply demonstrate that the evidence was stronger than critics assumed? And we've got about a minute.
Well, the probabilities are there. But I think it's better we put our house in order to get things done correctly so that we don't go bringing matters of conjecture and banding them as charges before the court, before courts, hoping that maybe in the course of trial or adjudication, we could be lucky to get a conviction or guilt. It is not done like that. There must be some specifics attached to prosecution. These specifics amount to the status of the agency, the quality of the lawyers, the nature of the offenses, the level of prosecution, investigation before the prosecution, that things are thoroughly done, that you don't just push a matter to the court anyhow, simply because you want to get a conviction, or maybe because you want to satisfy the authorities that the Federal Republic of Nigeria is on its toes in terms of prosecution. You are very, very correct, because for us to get a proper, particularly in high-profile prosecutions, there must be some elements of fidelity with the rule of law, with the due process of the law, with the provisions of the Constitution.
All right.
You know,
I want to thank you.
A very veritable level of cogency and validation. Thank you very much.
I apologize for interrupting you, but we are indeed out of time. Chief Festus Ogwuche is a lawyer and president of the Campaign for Social Justice and Constitutional Democracy in Africa. He was talking to me on the line there from Port Harcourt. Thank you very much indeed. That's it for this edition of Arise Prime Time. Join us again tomorrow. From me and the entire team here in Abuja and Port Harcourt, bye-bye, and thank you for watching.